Good afternoon, everybody, Fedhasa members, non-Fedhasa members, industry stakeholders, colleagues. A very warm welcome to you on a very chilly day here in Cape Town. Thank you for taking the time to join us today. It really is encouraging to see such a strong interest in what is clearly an important and evolving topic for our industry, hence the number of participants in the room today. Before we begin, I'd like to thank 𝗪𝗎 and the entire team at Big Ambitions for their support in bringing today's webinar together and for the work they continue to do behind the scenes to support Fedhasa and our members. The communications that comes from Fedhasa is always supported by the Big Ambitions team, and we thank them for their support always. More importantly, I'd like to extend a warm welcome to our two guest speakers. Thank you to Julia and Brett for giving us your time and for making the time to join us, and more importantly, for sharing your expertise with our members. Both of you work with these issues every day, and we really appreciate your willingness to help unpack what is a very complex discussion in South Africa at the moment. At Fedhasa, our role extends beyond advocacy, beyond golf days. We exist to support our members with practical guidance, credible information, and trusted partnerships that help hospitality businesses like yourself operate legally, responsibly, and most importantly, successfully. Hospitality is one of South Africa's largest employers and one of our most inclusive industries. Every day, our businesses bring together people from different backgrounds, cultures, and nationalities in service of a common goal, and that is creating exceptional guest experiences and providing meaningful employment and contributing to South Africa's economy. Hospitality is above all a people business, and our success depends on creating welcoming environments for our guests while operating responsibly within the laws of South Africa. Those goals are not mutually exclusive, they go hand in hand. And when uncertainty arises, our responsibility as your industry association, Fedhasa, it is our responsibility to create opportunities like today's webinar, where members can hear directly from experts, ask questions, and leave better equipped to navigate change and running your business successfully. Now, the issue around the employment of foreign nationals in South Africa has become one of the most discussed and at times most misunderstood issues facing business owners and employers. Proposed legislative changes, increased workplace inspections, and heightened public debates have left many businesses asking the same questions. What are our obligations? What has changed? What should we be doing now? And how do we ensure that we remain compliant while running efficient and sustainable businesses? And today's webinar is designed to help answer those questions. So today, our goal is not to debate politics or to advocate for a particular position. Fedhasa is and always will be a non-political industry association. Our role is to support our members and the audience in the room today by providing trusted information, practical guidance, and access to expert advice so that you can make informed decisions and continue to operate legally and efficiently. This is also not a legal consultation on individual cases. Rather, it is an opportunity to provide practical guidance on the issues that employers like yourselves are encountering every day, and to clarify some of the common misconceptions and point you towards the appropriate and professional advice where needed. So today, Julia will unpack the legal landscape and the questions that her team is currently fielding on a daily basis, while Brett will focus on the labor implications and the practical realities employers are experiencing on the ground. Then it'll be over to our members in the room. We will open the floor for questions, and we ask you to please use the Q&A function throughout the session. And if we don't get to answer every question today, we will use them to help shape a practical toolkit and a list of frequently asked questions that we'll share with members after the webinar today. Now, before we begin, I'd like to ask everyone to keep today's discussion respectful and constructive. This is a professional forum, not a political one. We recognize that people may hold very different views, but our shared objectives is to ensure that South African hospitality businesses understand their obligations and are equipped to operate confidently, legally, and responsibly. And our hope is that you leave today's discussion with greater clarity, greater confidence, and a practical understanding of what your business should be doing today. With that, let's get started. Julia, I'd like you to introduce yourself and begin by setting the scene from a legal perspective. What is the current position for employers, and what are the biggest questions your team is currently receiving?
Thank you so much, Leanne, and thank you for having me here. It's great to have the opportunity to speak to Fedhasa members. Yes, you've hinted at it. It's a disconcerting time for many employers, those who employ non-South African nationals. And just on the outset, I want to say there are no easy solutions at this moment. There are quite a few scenarios that the immigration system and asylum system intentionally has no solutions for. So unfortunately, I won't be able to wave the magic wand and resolve all issues, but what I would like to do is to provide some clarity on obligations on the employer side, risks, available options, also just an overview of the most relevant statuses that employees can hold and an idea of what of their scope. And also I'll run through a few typical, more complex cases that some of you may have come across that you might have questions around, and then end with the support that's available from our side. So if you allow me, I'll try and share my screen and a bit of a slideshow just to help you all go along. Yes, I think. Can you see it? Perfect. Okay, great. So as I said, I'll start with the obligations on the employer's side. The Immigration Act requires employers to at all times have a hold of the status that their employees have in South Africa and the rights to be in South Africa that they hold. So to have documents on file that prove their status and their ability to perform their activities for the employer as per their contracts. That includes for the South African citizens or permanent residents, it would be the ID documents, but otherwise it would be their passports and relevant visa copies in their passports or asylum papers and refugee papers. And also employers need to ensure that those documents are valid at all times, are extended in time, and relevant processes are kicked off timeously to ensure that there are no gaps. So the risks that employers face when not adhering to these rules are quite substantial, and they've become more real in recent weeks with greater, much stronger enforcement from the side of Home Affairs. So by law, it's fines and imprisonment that can be faced. The fines are actually on paper should be somewhere between 10 and 20,000 rand. There is draft legislation that's not in place yet, but I've heard reports. Brett may have heard of some reports of employees already being fined amounts like 100,000 rand. The draft legislation speaks of 100,000 or 10%, or up to 1 million, or 10% of the annual turnover, depending on which is higher. So these are hefty fines that can come your way, and even imprisonment up to 3 years in repeat offences. So, and on the side of the employee, of course, once found at the workplace without the right papers, that can lead to immediate arrest, deportation. That also means, of course, for the employer that the employee is gone from one day to the next, and not available for the team anymore. Also, once employees are found without the correct papers in the country, they will likely receive a travel ban and a restriction from returning to the country. If they only have expired papers, they can be banned for 1 to 5 years from returning. But if they are found in possession of forged or fraudulently obtained papers, then they can receive a lifelong ban, basically the prohibited status, so to say. What can one do? There are 4 steps that we recommend to make it really simple. The first is, of course, to collate all the documents that you have, and then the second is that you need to collate, not that you have, that the employees can provide to you. Then the second step is to verify them in terms of 3 pieces. The one is that they are authentic and genuine. I'll get into that just now, but they of course, it doesn't help the employer or the employee if it's a paper that looks good from the outside but is actually not on the Home Affairs system. And the obligation is on the employer to also ensure that, even if it is difficult to detect. The second one is that they're valid in terms of their expiry dates and validities. And the third is that in terms of their scope, that they allow not only the sojourn in the country, but also the activity that the employee performs for you as an employer and for your team as per their contract. Because not all statuses have the same scope. I'll get into that a little bit later. The third is then, of course, to look at what can be done to rectify any gaps, any inconsistencies. And the fourth, and this is not for the short term, but really there are steps that can be taken to plan ahead well and to prevent the kinds of situations that we find ourselves in now, by already going through these steps in the recruitment process. So when recruiting, already getting all the necessary paperwork, having them verified on the spot before a team member is taken on in the first place. Yes, so to go into the authenticity of the documents, the forged and fraudulently obtained documents are incredibly prevalent. They are so common. We perform verifications for employers, and it's not rare that 9 out of 10 documents or staff members are in possession of forged documents. Some nationalities are fall victim to this more than others, and different nationalities have different options and possibilities. I'll get to that, but it's something that's to be taken very seriously, and a document should not be trusted unless you really know what you're talking about. So there are various ways to get the documents verified. Home Affairs has its own routes and mechanisms. From what we hear, they're not always that reliable, but it is a route that can be taken. And then there are many providers who offer the verification from our side. We offer through a third-party provider formal verifications that counter-check the document against the Home Affairs database, but we also perform face value checks based on our experience. Those are faster and less costly, where we can tell with reasonable certainty whether a document is authentic or not. Then here I would like to just go into a little bit of detail on the different kinds of documents that you might come across. Often our clients have questions on what's allowed. I have this document from this employee. Are they allowed to work for me or not? And this is expired. They say they can still use it. Is that allowed? So just to give you a rough idea, and I'll go into some of the more complex examples later. So, of course, an ID document, and this is all assuming that they are valid and authentic. Authentic, not valid. The South African ID document, that means you're a citizen or a permanent resident, and there are no restrictions in terms of your activity, and it also doesn't expire. The asylum seeker permit you might have come across also allows for all activities. So any employer, any position, typically issued for 6 months, it can vary. A refugee permit, the same in terms of the activities, usually issued for 4 years at a time. Then we have these special vehicles that have been issued by the Minister of Home Affairs some time ago. The ZEP and the LSP are the most prominent ones for Zimbabwean citizens or Lesotho citizens. So those are special exemptions that also allow all activities, all work activities. And on paper, they have expired. The last of the LSPs and ZEPs that were issued expired in 2021. So if you look at the passport, you see the visa page with a visa stamp on it, and you see an expiry date of 2021, then it's very possible that that is a genuine visa. And because of a special exemption that was issued by the minister in reaction to court cases, these visas and permits are deemed to be valid until 28th of May 2027. So that is a document that allows employees to work for you until then. It's unlikely to be extended, so processes should be put in place to find solutions for after May next year, but they allow for this. And then other visas. So that might be general work visas. It might be a spousal visa. I'm going to go into them, study visas, etc. Those are very specific in terms of the activity that they allow for. So not all visas will allow for work for you as the employer, and most work visas are employer specific. So if somebody changes employment, changes company, changes employer, they will have to get a new visa. So it's they are restricted to what is in the conditions of the visa as stamped into the passport, and the same for the validity. The expiry date will be very clearly on the visa, and that needs to be monitored closely. And then the complicated and quite common scenario that we receive a lot of questions about are the receipts showing that applications have been made to Home Affairs through VFS, the Visa Facilitation Services. They show that an application is pending. It might be an application for a so-called waiver. Some of you may have come across it. It might be for a visa, or it might be a pending appeal for against a rejected application. Here, the rights under these pending applications are case dependent. I'll go into a few examples in a moment. But the receipt itself, presenting a receipt itself, is not necessarily sufficient to allow the person to work for you. So that is definitely something that should be checked with an expert to know whether you're in the green zone. And these, I'll get to the expiry date in a moment as well, but there is a special exemption in place that allows some applicants or applicants for certain categories of applications to remain in the country until 30th of June 2027. And also some of them are allowed to work. I'll get to that in a moment. Yeah, these are the common scenarios. As I've indicated, permit conditions, visa conditions are different according to category, and there are ministerial exemptions, there are directives that are issued regularly and changed regularly. So it's important to stay abreast of developments here, because they really are frequent to know exactly what the employee's rights are. So what I want to just explain is the pending applications for waivers, visas, and appeals. To explain what a waiver is, it's an application to be exempted from certain conditions that apply to any particular visa category. So it's almost a pre-step to the actual visa application. So I want to apply for a general work visa, but I don't have enough points to meet the requirements to get it. But I have really strong arguments to motivate why I should still be given this visa. So I apply for a waiver. I applied for a particular condition to be waived in my case because I bring such a special skill. I've been employed for 20 years in this company and I'm indispensable. So I apply for this waiver. And once that is granted, then I'm allowed to apply for my general work visa without meeting that particular criterion. So that is what a waiver is. Now, relevant at this very moment is the fact that the ZEP holders and LSP holders, they had the special exemption. This came out of special relations with the neighboring countries, and there were political reasons for granting them a status in South Africa. But the intention is for them to move over to the normal visa system. And for most of them, it's really difficult to qualify for a normal work visa. And to help that in a way, and to help the economy in holding on to some of the valuable employees that are not from South Africa, the practice on the side of Home Affairs has been to grant ZEP holders waivers more easily than usually. So if a ZEP holder is in long-term employment with their employer and they now want to switch over to a general work visa, and this changes and it fluctuates, but there was certainly a phase, and here and there we're seeing it again. Home Affairs was more inclined to grant this waiver and to say, purely based on the fact that you've been employed for long and that you had a ZEP and you never had any run-ins with the law, we will grant you the waiver. We will allow you to obtain this general work visa, even though you don't comply with any of the key criteria. So that is why many of the ZEP holders and many non-nationals in the country in general have been applying for these waivers in the hope that they can then qualify for general work visas, even though they actually don't meet the criteria. So yes, and here I want to differentiate. Firstly, the success chances of the waiver are much higher for those who still hold ZEP or LSP permits. Anybody else in lower or positions that require no skills or qualifications have a low chance of being granted that waiver, just for planning and prediction purposes. And then in terms of their rights to be in the country, the waiver application itself allows a person to remain in the country until the result is received, certainly until June next year. But in terms of activity, the ministerial exemption says that applications for a waiver allow a person to continue with the activities of their last visa. So it's if you had a work visa, then you apply for a waiver, you can continue working while you're waiting. And I think I'm getting quite technical here already, and this is something that I'll probably have to refer to individual consultations for, but just to give a rough outline of the complexities and of the different scenarios, and that there are different situations where somebody with the same kind of receipt, the one person may be allowed to work and the other person may not be allowed to work. So we really have to look at it in detail, see what was their status before and when did they apply. And so some of them may be allowed to work for you, but probably most won't. The same goes for pending visa, long-term visa applications. It depends on the date of application and the type of visa held before application. And similarly, regarding the appeal. Yeah, and perhaps one other example that comes up quite a lot is very different scenario. And maybe just to clarify, we have the visa and permanent residence scenario and a system on the one hand, governed by the Immigration Act, and we have asylum and refugee system governed by the Refugees Act. Currently very separate. They are planned to be joined into one big legislation, but at the moment they are very separate systems. And the asylum seekers and refugees, on the other hand, they up until now have been it's been quite a flexible system. So persons holding asylum seeker refugee permits could really take on any jobs, did not have to change their permits if they changed jobs. And because of the asylum system being so slow, they were able to extend their asylum seeker permits for years and years before their applications for refugee status were actually approved. So somebody coming into the country saying, I want to apply for asylum, I'm a refugee, will automatically get the asylum seeker permit while they wait for the final outcome of their process. And this is a temporary status. It's keeps getting extended until the refugee status is granted or it's denied. And these asylum seeker permits, again, were extended over many, many years. And on that basis, holders would be able to be in the country for many years at a time and work here. So this has changed somewhat. The Home Affairs has become stricter with issuing the asylum seeker permits, especially when applications come from countries where that are obviously safe at the moment, and many of the people having applied for asylum are really looking for better job opportunities in South Africa and not really persecuted. Anyway, I won't go into the detail. I'm seeing my time is running out, but this is just to give a hint of the complexity. And there are cases where formerly asylum seeker permit holders are attempting to apply for an extension and they are not getting the extension. So the status of these people is also contested, and that is something that individually we would have to look at and advise on. And lastly, the point that Brett will speak to in much more detail, the fact that an employee does not hold correct papers or even or that they have expired does not automatically mean that the employer is relieved from the obligations in terms of labor law, and can basically just tell employees to go home. So there are still strong obligations on the side of the employer, and that confirms the necessity to really check well in advance what the status is so that you can protect yourself and take the necessary steps in time. Here is just another overview of visa scenarios, and just perhaps very briefly to say for low-skilled positions, there are typically 3 scenarios that employees can qualify for a visa. That is, if they are married to a South African or a permanent resident or in a life partnership, or in some cases, if they have South African children. or if they're students, they can work part-time, and then also the ZEP and LSP holders. What to do when it's found out that the employee does not have a status in terms of immigration law. For asylum seeker and refugee permits, an attempt can be made to have them extended. But with expired visas, there is the option of getting a legalization in country, but those are the cases that is granted are very rare, have to be very well motivated. And otherwise, it is really leaving the country, probably receiving a ban to come back and then reapplying once that ban has expired. Yes, I think that is all I'll go into for the moment. And then, lastly, the support that we can offer, of course, is the verifications of the documents, and then advice on available options going forward, and of the rights of employees to work for you at this very moment. I think, that's the end of my presentation. Thank you. And I'll hand over to Brett. Yeah,
shall I jump in there? So I had a quick look at the audience, and there's quite a few names that are familiar to me. But for those of you who don't know me, I'm an office bearer at Fedhasa, and I assist in the employment dispute resolution function. And I've been doing it for the last 19 years with my colleagues at ILS. So listening to you, Julia, I'm probably going to overlap a little bit on what you've said there, but hopefully I can give some sort of practical little tips and steps that people can take in dealing with a particular challenge. But typically what happens is I get a phone call when the problem has already arisen. I get a phone call from a manager of a restaurant, for example. These are real situations that I'm going to mention now, where it's 40 of his staff members have been arrested on a Saturday night right in the middle of trade. Managers been arrested as well. Police, Home Affairs officials, Department of Labour officials arriving en masse to a property on a Friday afternoon just before a long weekend to come and do an unannounced inspection, and getting absolutely ready and willing to take people and incarcerate them for the rest of the weekend. The situation is real, and there's a high proportion of staff, I think we can agree, that are foreign nationals that are employed in the hospitality industry. So, but having said all of that, the problem that I've just described is a very preventable problem, provided that your responsible people, the business owners, managers, HR, and the rest of them are proactive in the management of their foreign nationals insofar as their paperwork is concerned. And it can come down to something as simple as creating a spreadsheet with columns of the names of your foreign national staff members, detailing what types of permits or visas they have, whatever conditions they are applicable to those permits, and then of course the applicable expiry dates, and ensuring that all of that is properly diarized, and that an allocated name, an allocated person, manager, is responsible for ensuring that a proactive engagement is held with the staff members before it becomes a problem. I was once dealing with a restaurant at the waterfront a few years ago, where they had an inspection. It was a few years before the current climate that we all know of, which I just described earlier, and before Operation 𝗪𝗪𝗪 and March became a thing, where I thought that the way that they sort of handled the situation was very good, in the sense that they built up a relationship with the Department of Home Affairs inspector for their particular precinct. They understood who that Home Affairs inspector was. They built a relationship. They reached out to the Home Affairs inspector, and they proactively engaged with this official and were open and insofar as providing him with copies of the documents and asking him to verify. And as long as they were proactive in dealing with it, the chances of them getting this unannounced raid would obviously be completely mitigated. But essentially what you'd want to do is obviously in proportion to the timelines applicable, you want to have a situation where the spreadsheet or the alerts and the calendar is reminding you six months before the expiry date of the individual concerned that you're engaging with this person. You're asking to make sure that they are getting their paperwork sorted out. You're developing a bit of a paper trail there with the staff member. There can be a follow-up engagement 3 months before the expiry date. Again, seeking clarity and copies of documents, and then reminding the employee of the looming expiry date, so that they're obviously aware that the time is drawing to a close, that they are going to be sitting very possibly in an inquiry with you if their paperwork is not in order. And what we would do is you'd want to, in line with Section 38 of the Immigration Act, which obliges a company to take reasonable steps, like Julia was intimating earlier, to take reasonable steps to ensure that it does not employ any person who does not hold authorization to work in the RSA, that you don't necessarily take the documents at face value. I think many of our audience members have come across a situation whereby they're faced with fake documents. And it's very easy, relatively easy, to have these documents verified through people like Julia and through someone from Home Affairs. Hopefully you can, because they're not always accessible. But certainly, there are officials in Cape Town that are accommodating, but that you are proactively engaging with people, experts who can give you feedback on the veracity of these particular documents. So to that end, what we do is we ask our staff members to write to sign off a consent form. And I will be sharing this with you folks. I'll ask him to pass it on. But essentially what it'll be is a declaration where the employee consents to the company inspecting their documentation and permits, either through a Department of Home Affairs or any other competent authority, namely an IMCOSA, and that the employee is made to understand that if there is any state change to the immigration status, including an expiry or cancellation or withdrawal of any renewal, that the employee may face an inquiry and the potential termination of the employee's employment. So the process itself, in the event that it is found that the employee does not have the required permit or what we call the legal capacity to continue employment, then at that very moment, the company faces risk. And it's the risk that Julia discussed earlier. It's fines and it's imprisonment. My understanding of it, and whether it's 10,000 Rand or 100,000 Rand, whatever it is, it's risk that no company wants to place upon itself. My understanding was 60,000 Rand and up to 6 months imprisonment. Obviously, fact is dependent, but from that very moment that the employee cannot continue employment, the company needs to take decisive action to engage with this employee and potentially formalize the termination of that employment. Now, what one would have to do, like the Code of Good Practice in the Labour Relations requires, is that you need to investigate the matter So you'd want to have an immediate engagement, a meeting with this employee, explaining the situation, and you'd compare it with with what you've investigated and what you have in your own paper trail, as I discussed earlier. But in the event that you feel that there is no justification legally for the continuation of the employment, then you're actually going to notify the employee of an incapacity hearing. And then for those of you who don't know, what's required to happen is that the employee needs to be notified of this meeting, this hearing, in a language and format that the employee can understand. And there's not necessarily going to be a charge attached to it, but the agenda that you're going to set down is incapacity to continue employment on the basis of an expired permit, whatever the case may be. You'd want to suspend the employee. I would advise that a suspension takes place, a suspension with pay, but you'd want to set the meeting, the inquiry down for within a reasonable amount of time. So it's typically 48 hours. And that's when you formalize the engagement with the employee and give the employee the opportunity to respond in a formal setting. You want to take minutes. You probably want to take a recording of the process. But, our law does dictate that employees be given an opportunity to present their own version of events, and that's what you will do. And this was set in stone a few years ago with a Labour Court decision involving Discovery Health, where they terminated the employment of a foreign national, believing that, once the person's permit has expired, that their rights to fair labour practice expired as well. And needless to say, that's not the case. Insofar as the CCMA is concerned and our labour legislation as it is, although the person may not have a valid work permit, as we've discovered, it doesn't mean that their rights to fair labour practice disappear as well. So the employee has the opportunity, like you would in a disciplinary inquiry context. The employee would be entitled to the right to a representative from amongst them, their fellow staff members, and to present evidence of their own. And you need to apply your mind to what gets presented to you. And again, you don't need to make a swift knee-jerk decision. If the employer has provided you with what you believe is a compelling version of why the employment should not be terminated, you can always reach out to the likes of Julia to double-check the information that has now been presented to you, and you can make your outcome having applied your mind properly to the situation. What happens on occasion, like just to double back to what I said earlier, is that you may discover that the employee has a falsified or false permit of sorts, and there are any number of corrupt Home Affairs officials who think nothing of pasting fake permits into people's passports. And at the face of them, they look absolutely real. And I'm not an immigration expert, and I look at it and I think that it looks valid. But for whatever reason, you discover, having engaged with an immigration consultant, say that it's a fake permit, or Home Affairs declares it as a fake permit, then what do you do? So you can charge the employee for dishonesty, but I don't think it's quite necessary. The underlying issue is that the person doesn't have the legal capacity to present themselves for employment. And what often happens is the employees present a defense that says, well, I didn't know. And that could very well be the case. They genuinely didn't know that this document that they've got in their passport is a falsified document. I dealt with a situation just last week where the employee herself proactively came forward to management and said, I discovered that permit that I presented to you, however long ago, it was part of a scam, and they are as victims of the situation, or they are victims of the situation. The next thing I just want to talk about is another sort of dynamic that's kind of come to the fore, being clients and members who phone us to let us know that they've received phone calls from people purporting to be from some other civic association, Operation 𝗪𝗪𝗘𝗥𝗘𝗗 or March to March, and they threatening to arrive at the premises, and they demand to look at employees' files and the rest of it. How should we deal with that? And my answer is we don't deal with those individuals, quite simply as that. My response is that the people that are authorized by law to be able to look at information personal information that pertains to our staff members, and that sits in files and it relates to their passports and all the rest of it, are the Home Affairs officials. And these are people that are licensed, and they need to identify themselves as official Home Affairs officials. And those people are the ones that we would defer to if in the event that you get approached by these civic associations and whatever, you'd simply say, look, I'm not in the position to engage with you. You'd probably want to ensure that some sort of security is engaged with, but we deal with Home Affairs and Home Affairs alone. I think I've kind of covered as much as I wanted to say. Like I say, I'm no immigration expert, but certainly from the side of process, for those of you who've dealt with these termination of employment, these dismissals, you would agree that the situation is not that different to any other dismissal in its process, being that the employee is notified. Like I said, you set down a process, an incapacity hearing. You table the concerns in the company's case, so to speak, and then you give the employee an opportunity to present their version of events and defense, apply your mind to it fairly, and then once again, try and ensure that this does not become a problem to start with by being proactive in the management of your foreign nationals and the permits. Thank you.
Sunette, we can't hear you.
Sorry. Do you want to go through some of the questions now? Maybe some that's going to be easy to answer in the 10 minutes that we have left. I don't know. I think if you can open up the questions and just see. I think some of them were covered in your talk. Well, let's just see if there are some that we can.
I'll deal with Cheryl. Hi, Cheryl. I saw your message now. It's the first one. And what if someone refuses to give that consent? Well, I think it's an entirely reasonable request. Fulfilling a legislated duty to undertake reasonable steps to ensure that the person holds the required paperwork to be able to. Another person refuses to give their consent to allow you to follow this process. Each case would be dealt with on its own merits, but on the facts before me, I would say that being a reasonable request, you can actually take disciplinary action against the employee for refusing to follow that reasonable request, which may in itself eventuate into final warnings and then even a dismissal. I think that was my first question that I saw there that I can answer.
Maybe I'll jump in response to the question about the waiver VFS receipts, if they are dated 2023 or a long time ago, in terms of whether they are still valid and whether the applications are still pending. That is something that can be checked. You're welcome to approach us and we can find out. And So it is possible that applications are pending for 3 years and no outcome has been received. So as long as no outcome has been received, then the receipt still has value. But again, I have to go back to what I said earlier. It doesn't necessarily mean that candidates are allowed to work based on that waiver. Waiver application.
I see that there's a question by Michael. I'm not in the position to answer that one from the top there. Look, I think what we did say that we'd do prior to this discussion is we'd collate the questions, and some of them that are a little bit more nuanced, we'd just apply minds to it a little bit better and give responses accordingly after the webinar. Now we're all going to be staring at the screen with questions.
I have more. There was a question about validity of asylum seeker permits. It is possible that they're issued for 1 year. As I said, it varies. So it doesn't mean that they fake just because they are, have a validity of 1 year. And then the ZEP, there is nothing in addition to the ZEP that needs to be shown. It's the passport main page and the page with a ZEP in the passport. Those two, together with the directives and court judgments, are sufficient to provide. So even if a Home Affairs inspection happens, then they would be satisfied just with a visa copy showing the ZEP of 2021.
So one thing that I sort of forgot to mention is that in dealing with a termination of a group of employment for a group of employees, I had to deal with Home Affairs here in Cape Town at quite a senior level, and the official that I dealt with indicated to me that there's actually a requirement on employers to report their findings of an employee who doesn't have the permit to the police. I haven't seen any authority of that, but nevertheless, it's quite illustrative of how serious they deem the situation. Julia, I've got a question for you. You had a slide there dealing with general work permits, and dealing with hospitality, you got, let's say, housekeepers, general workers, kitchen staff, and what have you. And an individual who has a general work permit to be able to work in that type of level, is that something that's possible, or is it something that it requires a special skill that they needed to have attained or qualification?
So it's unlikely that a general work visa would be issued for that kind of position. And there are exceptions. For instance, if somebody changed from a ZEP, received a waiver, and then received the general work visa. But those are few and far between. Usually the visa system is created in a way that it would not allow for visas for these kinds of positions, because to protect the local labor market, because we have enough South Africans who can fill those kinds of positions. But there are exceptions. Does that answer your question?
Yeah, thank you. Yeah.
Okay. Then I just want to go back to, it was anonymous. Sorry. Nonzukiso, about the receipt. If somebody has a receipt, in addition to that, we would have to see what status they had at the time of application. So if the receipt is dated May 2023, we need to have the copy of the page in the passport that shows a visa, a status, a stamp, that shows what the status was in May 2023 when they made their application. And then I think Shepard's question is for you, Brett, if you can find that from 1229. I'm going to have a look at that.
I'll give it my best shot. I just want to find out a scenario where a ZEP holder has a valid fixed term contract. I guess that will obviously expire at the end in this case 2027. With what is currently happening, where they are told to pack their bags and leave the country, from a contractual obligations, how is this terminated treated? The employee has not resigned and the employer did not fire him. As a follow-up, what package or terminal benefits is the employer obliged to observe? This employee has, and again, I just want to give it with a big fat caveat that each situation is dealt with on its own merits, and what I'm going to say now has to be applied in a context of an engagement with this employee, a formal engagement with this employee. But typically, employees have a legal, contractual, common law duty to provide their services to their employer, to work for the receipt of money. And as long as this employee is not providing their services, they are in breach of that contract of employment, and the company can consider taking disciplinary action against the employee accordingly, whether it is that the person has absconded or was been simply absent without leave for a period of time. So in that event, you wouldn't be obliged to pay a package. The services would be terminated summarily. But certainly you're going to have to, again, give the employee an opportunity to ventilate their versions of events in a formal process, what we call an inquiry, and then you take it from there. I hope I was going through the questions quite quickly. I hope I picked up the question accurately.
There are two questions from Zinat. Specifically on the wording of the general work visas, difficult to say in general because different consulates and embassies have different practices of the wording that they use, and even with regards to the conditions. So an employer should be mentioned on the general work visa, but there are exceptions. So as a hard and fast rule, yes, it's employer specific and it should say visa, not permit. But there are exceptions. So if you have something that looks unusual, if it says permit, if no employer is listed, then it's in general you should verify them. But specifically in those cases, you mentioned another in your second question, another particular wording in the general work visa to take up employment and study. Unusual, again, I would test it and have it verified.
Okay, this is from a person I know reasonably well. Layla, are all asylum seeker permits acceptable for employment purposes, regardless of nationality? Or are there nationality-based restrictions we should be aware of? That's a question for you, Julia.
Sorry, and then I was reading another question.
Oh,
I wasn't listening to you, sorry. Where is that? What time was it?
12:50.
55.
Sorry, I'm going as far down as I can to find questions that I can give answer to.
Yes. Okay, Leila's question I can answer. Yes. Irrespective of nationality, if it's a valid asylum seeker permit, yes, then it allows for all kinds of activities, irrespective of nationality. The only thing perhaps that is
the hour mark.
Oh, okay.
So I'm just worried that Zoom is going to cut us off. But please, everybody attending, we will get to your questions, and we will respond to them as soon as possible afterwards. Leanne, I think I'm going to hand over to you to close us off for today. Thanks.
Thank you so much. Firstly, to Big Ambitions for setting this up for us, to my Fedhasa colleagues across the country for joining us and for the support. Julia, Brett, thank you. You did a really good job in communicating a very complex situation. It was digestible and easy to comprehend. There I think the key takeaways is that all of these scenarios have to be assessed on a case-by-case basis, right? And the duty of care does lie with the employer, both in terms of making sure your own house is in order and making sure that your employees' houses are in order. There is support available through your Fedhasa channels to access this type of information. Please feel free to reach out directly to Brett and Susan, Brett and Julia directly as well, if needed. But from a Fedhasa point of view, we are going to do our best to put together a frequently asked questions pack for you with the examples. For example, Brett mentioned a spreadsheet template. So from a Fedhasa point of view, we'll try and put together as comprehensive a pack as possible. But I sound like the legal experts in the room. Every situation is a case-by-case situation. And Brett, I think your advice today was golden. Make friends with your Department of Labour representative. Right. I think they're just doing their jobs. And I think if you build a solid and positive relationship from the start and be proactive in managing these relationships, as with everything in life, it'll go a lot smoother. So thank you for these takeaways. Thank you for everybody for taking your lunchtime hour to join us. At one point we had almost 190 people on the webinar, which I think shows the importance of this discussion. And thank you for supporting Fedhasa. We appreciate it. Thank you.